It's whenever you're ready, John.
Okay, great. Um, Thank you, Dan. I'm gonna get I'll introduce myself to the folks I haven't met yet, and then I'll jump right into the screen share presentation. Whoa, we already lost. Um, so for folks I haven't met yet, my name is John Guzkowski. I'm a planner and zoning officer with Tyche Planning and Policy Group, and have also been helping the town of Portland for the last year and a half or so, doing a couple of various land use things. Before Dan was brought on board, my colleague Mike and I sat in as the town planner, and I zoomed in on one or two planning and zoning meetings in that time. And then after Dan's return to the town, we've been helping out doing some zoning enforcement and some economic development assistance. Um, but my practice as a planner is basically assistance with planning and zoning and zoning board of appeals and economic development and community development stuff in towns across Connecticut. And so for the last 20 plus years now, so I've had a lot of experience working with land use boards. And this evening we're going to run through, hopefully relatively expediently, a very nuts and bolts presentation that goes into, and I don't know if all of you are planning and zoning commissioners or ZBA members, but we're going to cover both actually planning, zoning, and zoning board of appeals in terms of the statutory structure of them, your roles and regulations, what you can and can't do, and a little bit about meetings. Um, Feel free absolutely at any point to jump in and ask questions. We will hopefully have a little time at the end for questions as well. But the small group and you've all been participating in these boards and commissions, so you have some level of expertise. So please understand again, this is nuts and bolts. I'm sure a lot or most of this, but I think it's important to kind of go through a little bit of a baseline to make sure everyone's on the same page with what the rules and procedures are. So without further ado, we'll jump in to the presentation. And does that look like a PowerPoint presentation? Okay, great. So we're going to start with zoning commissions. The statutory legal basis. The state does not mandate zoning commissions. Towns can choose not to have zoning commissions. And so the chapter 124 of the general statute says a municipality may, by vote of its legislative body, create a zoning commission. Almost all of them do. I believe there's maybe one, maybe two towns left that still don't have zoning. Obviously, Portland has had it for quite some time. If you do have a zoning commission, which obviously Portland does, you are also required to have a zoning board of appeals because that is a mandatory sort of check and balance on the zoning commission. The duties, according to state statutes, of what zoning commissions do, obviously first and foremost to establish zoning regulations, which includes repealing them, includes changing them, and zoning districts, so where things are allowed to happen. To hear and consider petitions to change those regulations and zoning district boundaries. So again, someone wants to change the regs, someone wants to change their district, you are empowered to hear those and consider them, to provide for the manner in which the regs are enforced, and to take legal action on enforcing them. And then again, to certify when it's appropriate that a structure or use will conform to those regulations. And those last two, in many cases, and in fact, in Portland's case, that's generally delegated to staff, and in this case, delegated to the zoning officer. Both Dan and myself are duly appointed as zoning enforcement officers, and so in that delegation, we are authorized and responsible to do the interpretation and enforcement of the regulations, but that power comes from the zoning commission. It's authorized to do very specific things in terms of regulation. Sort of the basics: height and size of structures, maximum height, coverage, maximum size, the percentage of the lot, lot coverage, size of yards and other open spaces. So basically your required setbacks, population density, and in other words, minimum size of lots in different districts, so 1 acre zone, half acre zone, etc. The location and use of buildings for different purposes. So you have residential zones, business zones, mixed use zones, and a lot of those things are water dependent. Obviously, Portland being both on lakes and ponds and on the Connecticut River has some additional sort of responsibility to consider water dependent uses and things like height, size, locations of signs and billboards. Though we are not authorized to regulate color, design, and in more recent years, content either, except in certain circumstances. Things that the commission is not allowed to do is to prohibit outright, refuse to allow family or group daycare homes in residential areas. Those are as of right per the state. Put conditions on manufactured homes with more than 22-foot widths and are conforming to federal standards. So this is something that is put down by the state, that you are not allowed to regulate manufactured homes in a way that is different from other single family homes. In the last couple of years, the state included another thing that zoning regulations cannot do, which is imposing a minimum dwelling unit size apart from building or public health code. A lot of towns did have, if you were going to build a new single family residence or an apartment building, the minimum dwelling size, maybe 1,000 square feet for a house, or 600 feet for an apartment. Those are now prohibited by state statute, and the only thing that controls the absolute minimum size of dwelling units is building code and public health code, and those numbers are very small. It's something on the order of 120 square feet per person. So you could have very, very small dwellings as of right. You're not allowed to impose conditions on developments to be occupied by manufactured homes, which are different again from multifamily dwellings or clustered planned unit development. So again, there's not an ability to discriminate based on the type of manufacture of the house, stick built versus manufactured. And you're not allowed to prohibit construction or operation of solid waste facilities, but you are allowed to regulate them. And this is something that is happening currently, a battle that's happening currently down in Deep River, where a solid waste facility exists and is looking to expand, but the town is by zoning saying no. And we're setting up a little bit of a battle with DEP about that one. So so you're allowed to regulate but not prohibit. Some additional things that zoning regs can't do is prohibit the continuance of a non-conforming use, building, or structure that existed when the regulations were adopted. This is essentially the grandfather clause, that if something existed as a use, as a structure at the time a regulation went in place, it is allowed to continue, and you are not allowed to extinguish that. Nor are you allowed to terminate a non-conforming use solely as a result of non-use. So in other words, perhaps you had a gas station that was in a residential zone that wouldn't have ordinarily been allowed. If the gas station closes, changes ownership or goes idle for a period of even several years, you are not allowed by zoning regulations to terminate that use going forward. It is allowed to essentially restart unless the property owner affirmatively makes a statement that intending to abandon and discontinue the use in perpetuity. So those things are basically allowed to get restarted once they have existed. Similar to the daycares, you're not allowed to treat residents of 6 or fewer people with mental or physical disabilities or people receiving mental health or addiction services as any different from a single family residence. So anywhere residences are allowed, these facilities for 6 or fewer people are allowed. Or similarly, to prohibit community residences for mentally ill adults in any area zoned to allow structures with 2 or more dwelling units. So if you allow duplexes or single family with accessory apartments, these residences for mentally ill are allowed to happen as well. The zoning regulations at a local level cannot. A little bit about the grandfathered uses or structures. Again, you cannot retroactively prohibit them and eliminate existing non-conforming uses. Again, as we said, you can't just by mere non-use, if something goes idle for a number of years, even many years, it is allowed to restart. If a building is erected in a non-conforming way, which is to say you build a shed or a garage or a barn too close to the neighbors and in the setbacks, and it's not enforced. It's not caught. No one enforces it. It's not brought to the owner's attention, and it's there for 3 years. It's allowed to stay. It basically becomes existing non-conforming, and it is allowed to remain. There is a great deal of discussion about expansion of non-conforming uses versus intensification of non-conforming uses, and this continues to make case law. But for instance, this is sort of known as the baby elephant problem. That if a non-conforming use is in a spot, let's say a small pub or restaurant that lived that was established in a residential area many years ago, and all of a sudden becomes super popular and it becomes the hot spot to go to. Simple intensification of use, just the fact that more people want to go to and participate in this non-conforming use or structure, does not mean that it has to go away, or does not mean that it expanded its nonconformity. However, a physical expansion, let's say there was a gas station in a nonconforming zone, and they wanted to knock down the little shed of a kiosk where the cashier used to take the money, and blow it out into a whole 7,000 square foot convenience store. That's an expansion that would not be allowed without a variance. So and exactly where the lines are between intensification and expansion of nonconformity is something that there's been a lot of case law and will continue to be a lot of case law about. There are a couple of different types of zoning applications that the zoning commission is sort of allowed to categorize. There are basically simple administrative permits, which is again an as of right, usually something like a single family residence in a residential zone, or an accessory shed or an agricultural use, is generally allowed as of right at staff administrative standpoint. There are site plans, which is generally a commission application, and then special permits or exceptions, which is also a commission application that it has a special process and a public hearing. There are also a couple of other special types of applications. Obviously, applications pursuant to 8-30G, affordable housing. We've had a lot of talk about that in the last couple of years. Is a special type of application that essentially flips the burden of site plan review and forces the commission to decide why an application should not happen rather than why an application should. Floating and overlay zones is sort of a special application that lands a different district under certain circumstances, usually a master plan process. RLUPA, which is the Religious Land Use and Institutionalized Persons Act, which basically forces commissions to not make special rules that would exclude institutionalized person uses or religious use uses. And then there are FHA, fair housing, ADA, Americans with Disabilities accommodations that in many cases sort of bend the regulations a little bit to provide some accommodation for protected classes. Changes of zoning regulations or district changes. These are things that, applications that the commission could make themselves, or individual property owners or residents could petition the commission. These are very broad. They offer very broad discretion. There's not a simple, if you check these 5 boxes, you will get your zone change approved, or you will get your text amendment approved. So creation of a new zone, say you want to do a mixed use zone or a waterfront overlay, change the regulations, maybe increasing height or decreasing maximum intensity of lights, whatever the regulation changes are. These are treated essentially as special applications. A public hearing is required, generally notification of abutting property, of abutting towns, or the regional council of governments is required to be notified of these changes. Basically the guidance that the zoning commission must act upon is, does this change, either the change of zoning designation, say from residential to commercial district, or the change in text, say of change of maximum height, is this in conformance and does it advance the goals of the master plan, the plan of conservation and development? And does this, is this something that will not adversely affect the public health, safety, and welfare, which is your fundamental sort of police power as a zoning commission? And so that is what you must decide as a zoning commission when you are given an opportunity to change either the regulations or the zoning map. Is does this protect the public health and safety, and does this advance the goals of our master plan? And if it does both of those, generally speaking, that regulation or that map change should take place. Minor caveat to this is spot zoning. If a change is proposed that affects just a single property for a single purpose, that is not more broadly applicable to other properties in that area, and it sort of has the appearance of contract zoning that or basically a deal to accommodate a single property owner. That's generally considered spot zoning, and those decisions have often been struck down. However, if that change to a single property can be found with a straight face by the zoning commission to advance again the goals of the plan of conservation and development, then very often those things can also be considered valid. Site plan reviews, which again in Portland and many other places is a commission action. It does require a full application to the commission and consideration. But this is a use that is permitted in the zone. The commission has very specific standards for things like setback heights, coverage, stormwater drainage, lighting, and whatnot. But it is strictly an administrative review. There is no negotiation. This is if the commission deems that the application is complete, that they have all the information that's required, and that the application checks all of those boxes against the standards that it places in the regulations, that approval must be granted. If it doesn't, obviously it can be denied. But there is no negotiation like, could you move this over here, or maybe you could lower the roof line, or maybe we could, reconfigure the parking. It is really a black and white thing. If it meets the standards, it must be approved. And for a site plan, public hearings are not mandated. They can be required if the commission deems them appropriate, and if it's set forth in the regulations as a potential option. For special permits and special exceptions, which are used basically in Connecticut interchangeably, a special permit is exactly the same thing as a special exception as far as Connecticut law is concerned. And these are discretionary acts, that these are uses that are generally not allowed as of right in the particular zone or area. But if the applicant can demonstrate that it is appropriate in that area, and again, will not create public health, safety, nuisance issues, will advance the goals of the plan of conservation and development, then it can and ought to be approved. Some commissions delegate special exceptions or special permits to the Zoning Board of Appeals. Some actually delegate it to a separate planning commission. Obviously, in Portland and many towns, you have a joint planning and zoning commission. And so that entity handles all special permits and special exceptions. And if there is a part of the project involves a regulated activity, something that is taking place in or near the wetlands, the application must be delivered to the Wetlands Commission no later than the same day it is delivered to Planning and Zoning. And Planning and Zoning must wait on the wetlands decision before it acts upon the special permit. It does not need to wait for a wetlands approval, just action. So in theory, something could be denied at wetlands, but approved at Planning and Zoning. It obviously wouldn't get built because it wouldn't have wetlands approval yet. But Planning and Zoning is not required to wait for an approval, just a decision. Okay, so now jumping over to the Planning Commission, which obviously in Portland is the same entity as the Zoning Commission. However, the statutory responsibilities are different and separate. They exist in a different portion of the Connecticut General Statutes and empower different sorts of things for the Planning Commission. A couple of the things that the Planning Commission is empowered by state statute to do and is required by state statute to do is the adoption and updates of the Plan of Conservation and Development, which is a 10-year process and is in theory the guiding document for many or most municipal decision-making decisions about municipal investments and rules and procedures. The Planning Commission is also empowered and in fact required by Section 8-24 to review proposed municipal improvements, which includes extension and widening of right-of-ways, streets, bridges, parkways, public ways, locating schools, parks, playgrounds, airports, or other public buildings, locating or expanding public housing, or redevelopment or urban renewal projects, as well as extension of public utilities such as public water, sewer, lights, power, and all of these municipal investments are referred to the Planning Commission for a report before it happens. And the Planning Commission is responsible for determining whether that municipal improvement, whether it's acquisition of property, acquisition of open space, extension of sewer lines, building of a school, if that project, again, is in conformance with the broad goals of the Plan of Conservation and Development. And it is supposed to deliver that report within 35 days of the referral. If the Planning Commission does not act, it is deemed essentially an approval. If the commission denies it, if they find that, nope, running this sewer line into what we hoped for would be open space is not in conformance with the Plan of Conservation and Development, they issue basically a denial. That changes the vote of the town council or the representative town meeting to a supermajority. So if, for instance, the town wanted to extend sewers into what should be open space according to the Plan of Conservation and Development, the Planning Commission says, no, we disagree with this. The bar would be 2/3 vote to override the Planning Commissions. And if you do not get that 2/3 vote, that public improvement cannot happen. This 824 very frequently does not really apply to basic maintenance of public property. So if you're going to replace some sewer lines, you're going to upgrade something, you're going to upgrade a pump station, that doesn't necessarily need an 824 referral because that's considered maintenance. So again, as you know, being on the Planning and Zoning Commission, there's another set of regulations that you're responsible for. In your role as the Planning Commission, you're responsible for establishing as well as changing or repealing subdivision regulations and review and approval of subdivision applications. Subdivision applications are an administrative review similar to a site plan review. A subdivision is defined in state statutes, is a division, a tract of a tract or parcel of land into 3 or more parts or lots for the purpose, whether immediate or in the future, of sale or building development, expressly excluding development for municipal, conservation, or agricultural purposes. So there's a couple of elements that are important there. Division into 3 or more parts. So very often you hear that a parcel that existed before subdivision regulations were in place, which I think in Portland was in the mid 60s somewhere. If a parcel existed, it is allowed to have a free split or a free cut, where you can basically divide a piece of property in half or carve off 2 acres or something like that without being part of the subdivision process. But the next division of that land, of that original parcel, basically the 3rd lot, the creation of that 3rd parcel would begin to trigger the subdivision regulations. And the other element of this is for development for municipal, conservation, or agricultural purposes. So if, for instance, a farmer who had 100 acres of fields and was dividing up his land amongst his heirs or her heirs, giving each of his or her 4 children a 25-acre piece of farmland to farm for farmland or conservation purposes, that division of land could occur administratively by just filing a map and a deed. Because it's conservation purposes and not for development purposes now or in the future, it is not considered a subdivision. Planning and zoning may hold a public hearing on a proposed subdivision as opposed to a re-subdivision, which we'll talk about in a second. But it doesn't have to. And this is not just residential. any type of development of land or any type of division of land for development purposes, including commercial or industrial subdivision, would fall under those regulations and that authority. Subdivision definition also includes re-subdivision, which is a change in map of an approved or recorded subdivision or re-subdivision. If the change affects street layout, if it affects any area reserved for public use, or diminishes the size of the lot, or creates an additional building lot, following the approval of the original subdivision. So basically, once you do your first split, now you have two lots. Once you create a third or more, you're in the subdivision category. Once you come back and re-subdivide that land, you're in the re-subdivision category. Or if you're adding public roads to that area, it becomes a re-subdivision. And in that case, a public hearing is required by state statutes. A couple of things that must be in subdivision regulations that are, again, created and under the authority of the Planning Commission or the Planning and Zoning Commission using their planning function. Again, land needs to be divided in a way that does not endanger public health or safety, so it's orderly development. You have to make proper provision for water, sewer, and drainage, as well as flood control measures, particularly those areas that border bodies of water are subject to flooding. That the streets created, the pattern and network of streets are harmonious with the plan of conservation and development, and create a safe condition in terms of intersections, arrangement, width, slope, and that sort of thing. So we can ensure that the public health and safety is protected for present and future traffic. You are not, however, allowed to deny a subdivision on the basis of offsite traffic. If there is a troublesome intersection that's just down the road from a proposed subdivision, and that subdivision, obviously, you're creating more lots, you're adding traffic that's going to exacerbate the situation at that dangerous intersection. That is not a reason that you are allowed to use to deny that subdivision, because that offsite traffic is the town's problem. It is not the developer or the property owner's problem. You can only use traffic studies to affect internal circulation and circulation at the entrances or exits to that subdivision. So if there's a new road, a new cul-de-sac, or a driveway, if that driveway or new road creates a hazardous traffic condition, then that is a reason to modify or deny a subdivision application. But something that happens even close by but offsite is not fair grounds to deny. A couple of other things is you have to provide adequate provision for soil erosion and sedimentation protection, passive solar energy, so the arrangement of houses to make sure that there's maximum solar gain. And then this similar to opposing requirements on manufactured houses that would be somehow different from other type of construction techniques. Things that are optional in subdivision regulations that many towns have required is street grading and improvements. So the specific requirements, provision of public utilities and services. Maybe many people require in subdivision regulations, you bury your utilities or provide for a bond for the completion of public improvements if they're not done immediately following the approval. Can encourage energy efficient patterns of development, and you also enable, and many towns have taken advantage of this, is to provide for clustering of development, which is would be consistent with the topography and soil conditions of the land, which again would allow for placement of the same or more houses on a smaller portion of land and setting aside of a larger portion of open space. However, all of these things need to be empowered and coordinated with zoning, and the subdivisions are not allowed to create new lots that do not conform to zoning regulations. So for instance, if there was a minimum 2-acre zone in a certain area, someone couldn't do a subdivision of 1-acre lots because it does not conform with zoning. So those things have to be harmonious. Other things that are allowed to be in subdivision regulations are provision of open spaces for open space parks and playgrounds in areas that are deemed appropriate by the commission. The open space must be shown on the subdivision plan. It should have some nexus, it should make some sense with the scale of the subdivision itself. The statutes don't address how much land can be dedicated. There is, for fee in lieu, there is a 10% max for fee in lieu. However, the percentage of open space is not explicitly capped by the subdivision statutes at 10% or at 15% or at 20%. The cluster subdivision regulations actually set a minimum standard of 33% open space and explicitly do not prohibit towns from going higher than that. The land is the open space can be dedicated to the town, land trust, neighborhood association, homeowners association, and the developer cannot demand, the property owner or applicant cannot demand, or the applicant can retain title to the land. Again, we talked a little bit about open space fee in lieu. In many towns, instead of setting aside little pieces of open space as part of every subdivision, we'll take a fee, and that is generally capped at 10% of the pre-development value of the land, and that gets put into an open space fund where the town could fund acquisition of open space somewhere else in town. Other things is, unlike the zoning regulations, which cannot be waived, and it's the only responsibility of the zoning board of appeals to change the applicability of zoning regulations in a specific circumstance. Subdivision regulations can be waived if 3/4 of the planning commission, of the voting members, determine that special conditions exist, and in those circumstances, the applicant could argue that a portion of the subdivision regulations should not apply to them, and the commission can essentially waive their own regulations when it comes to subdivisions. In terms of changing subdivision regulations, if the planning commission changes subdivision regulations or the zoning commission changes zoning regulations, and a subdivision that was approved prior to that change and is filed on the land records as such, those plans are essentially locked in at the regulations that were in place at the time of subdivision. So, for instance, if a subdivision existed in a 1-acre zone with 20-foot setbacks and was created, so you have all these 1-acre lots, and the town subsequently said, okay, no, this neighborhood is now going to be 2 acres with 50-foot setbacks, and that change happened after the subdivision was approved and filed, those lots would still be regulated under the old set of zoning and subdivision regulations. So 20-foot setbacks would still apply to those lots. In terms of required improvements, generally speaking, there are a 5-year time frame for public improvements. Let's say it's going to be a cul-de-sac on a road, on a new cul-de-sac road. That road must be built and complete within 5 years. However, the commission can allow an additional extension, and very frequently, a bond is put in place to make sure that those public improvements extensions, which would include roads, sewer lines, water lines, drainage, open space, and that sort of thing, would take place. Okay, zoning board of appeals. So, as we said at the very beginning, if the town creates a zoning commission and establishes zoning regulations, it also must establish a zoning board of appeals to look at issues of appeals and variances to those zoning regulations. The makeup of zoning board of appeals, unlike planning or zoning commissions, which does not have a defined number of members, zoning board of appeals must have 5 regular members with 3 alternates. Each town can decide whether or not the members are elected or appointed and how vacancies are filled, but there must be at least 5 regular members, 3 alternates, and minority representation applies. It cannot be all 5 members of the same party. So the zoning board of appeals jurisdiction includes a couple of things, actually a smaller list than it used to at this time last year. Zoning board of appeals deals with variances of the zoning regulations, appeals from orders of the zoning enforcement officer if the person receiving the order, a cease and desist or a notice of violation, disagrees, they can take their case to the ZBA. And in some cases, the zoning regulations delegate special exceptions to the zoning board of appeals. I don't believe that's the case in Portland, but many towns do delegate certain special exceptions to ZBA. The thing that we crossed out here is certificates of location for car dealerships, motor vehicle repairers, or gas stations. For many years, actually until this most recent legislative session, which ended in June, review and granting of certificates of location and appropriateness was delegated to the Zoning Board of Appeals. That was changed. Now, so ZBA will no longer, for the foreseeable future, be seeing those applications. Instead, the zoning enforcement officer, the ZEO, is delegated those reviews. So that was kind of an odd carve out for ZBAs, and really nobody had a good reason for it at the legislature. I think it was basically a favor done by one legislator for probably one car dealer or one gas station in their town. And it was changed for the state for a period of 10 or 15 years. And so that's been eliminated. So ZBA no longer has that responsibility. Excuse me. In terms of making decisions, 4 affirmative votes are required. So basically a supermajority of those voting, 4 of 5 members or alternates, are required to grant a variance or to overturn the decision of a ZEO that is being challenged by an applicant. If there are only 4 members in attendance, and very frequently, you may not get a full membership, and very often, commissions aren't fully staffed up in terms of their roster. If you have only 4 people in attendance, it must be a unanimous vote. You need 4 affirmative votes, not just a simple majority, not 3 of 5, not 3 of 4. It needs to be at least 4 affirmative votes. Variances are generally the primary function of the Zoning Board of Appeals. And again, this basically is a statement by the Zoning Board of Appeals that the strict interpretation of the zoning regulations in a very specific circumstance do not apply. So if someone wants to put a barn in the setback, or if someone wants to put a ramp, extend a porch into the front yard setback, or someone wants to go up above a 35-foot height, there has to be very specific circumstances, and the Zoning Board of Appeals, basically in a quasi-judicial capacity, has to determine if there's something about that application that makes sense, that makes it necessary in many cases to basically say the zoning regulations do not apply in this circumstance. And that approval, that variance, runs not with the property owner, the applicant, but it runs with the land. So if someone gets a side yard setback variance, it does not extinguish when that person moves or dies or sells. It continues in perpetuity on that property. There are requirements per the Connecticut General Statutes that created variances, Section 8-6C3. The variance cannot substantially affect the comprehensive zoning plan. So it cannot be a change that basically changes everything in zoning or changes things across a zone. It has to make the decision that strict application of the zoning regulations, as we said, will create an unusual hardship unnecessary to carrying out the general purpose of the zoning plan. So it needs to look at the intent of the zoning regulations in that district, and generally speaking, and determine that if this applicant was required to strictly abide by those zoning regulations, that creates a hardship that was not intended by the zoning regulation. The hardship has to arise out of the application of the zoning regulations themselves. It cannot be something that is self-imposed. That it cannot be that, well, I have to put the barn over here because I built my addition up the back over here. And so I've created a situation where there's no more land in my backyard. And so I got to put the barn over there. That's a self-created hardship. That is not something about the zoning regulations themselves. And the applicant has the burden of proving this hardship. It is not something that the commission or the board offers to say, oh, how about this? No, this has to be proven by the applicant. Simply the loss of competitive advantage is not the basis for a variance. So for instance, if you, let's go to our gas station choice, that again, it's a gas station in a residential area. It's a small kiosk. There's not a huge convenience store. And the owner of the gas station can't come and say, listen, I don't have a convenience store. I can't compete with Cumberland Farms down the road. I'm going to get put out of business. Competitive advantage is not a reason for a variance. So, and the financial considerations are generally only relevant if that strict application of the zoning regulation completely destroys or drastically reduces the value of the property. So even if that gas station, and again, this is the strict read of the statutes, even if that gas station is likely to go out of business if they are not able to put up a Cumberland Farm style convenience store, they still exist in a residential district. And that piece of property still has the right to be a single family residence. So all of the value is not removed from that piece of land, even if economically it can't be a gas station anymore. That is not, by statute, a reason for that hardship. A couple of examples of the hardship. Again, there's no market for the property without the requested variance, that there's no other thing that can be economically done on that property. That some actions of public authorities cause a problem. For instance, if there's a huge utility right of way going through the backyard and you're unable to build anything back there, that might be a reason to create a variance to the regulations. Something about narrowness of the lot, if it was happened to be created before zoning at a way that prohibited, say it's only a 60-foot wide lot, and you have 35-foot side yard setback. So essentially there is no place that's buildable on the lot. That's reason for a hardship. Topography, so if it's entirely ledge or if the majority of it is in wetland or underwater. If there's an honest error by a contractor, prior zone change application. So again, if zone changes occurred that rendered something about this property unbuildable under current zoning regulations, unusual soil conditions, drainage, locations of well and septic systems, for instance, because in areas without public water, you have a 75-foot well radius, and perhaps the well next door is right near the property line, and it basically confiscates a large portion of the abutting lot for being able to put structures. That's a reason for a variance, or wetlands. Those are generally considered structural variances. The zoning commission can also allow the zoning board of appeals to do use variances. Many zoning commissions basically prohibit use variances, and it's variances for other uses that would be allowed in other areas of town. So, for instance, back to our gas station example, that applicant could request that in this circumstance, on this piece of land in the residential zone, that a gas station be allowed. That would not be the case if they were looking to do a slaughterhouse or something like that that might be prohibited throughout town, or a nuclear waste repository that would not be allowed elsewhere in town. You can't do a use variance for something that's not allowed at all. But for something that is allowed in a different district, the zoning board of appeals could do use variances. However, not if the zoning commission specifically prohibits them. The other element of the role of the ZBA is appeals for decisions by ZEO. The ZEO, again, is an administrative officer charged with interpreting and enforcing the zoning regulations. And we, issue certificates of compliance, also issue cease and desist orders and notices of violation. If applicants believe that they are the zoning regulations are being interpreted incorrectly, or the cease and desist order or notice of violation is being imposed unjustly or arbitrarily or capriciously, that applicant can challenge the zoning officer's finding, and has a time clock to appeal that decision, generally within 30 days, or otherwise set forth in regulation. The notice of appeal has to be served to the zoning officer or the zoning commission within that appeal period, and then it goes to the zoning board of appeals for review. Okay, those are the three basic boards and commission entities. A little bit about processing applications. When applications come in, and this is in the case of all three commissions, planning, zoning, and zoning board of appeals, the application, the official date of receipt is the earlier of the next regularly scheduled meeting, and at the end of the year, beginning of the year, you have to submit your regular scheduled meeting for the entire year, or 35 days after filing, whichever is earlier. So many commissions may cancel a meeting or have no August meeting, and so if 35 days elapses between the time of application and the next regularly scheduled meeting, then 35 days after it is deemed received. Time limits, again, set out by statutes. Site plans have to be decided within 65 days, or within 35 days after inland wetlands reports and makes their decision. All other applications, the public hearing has to take place no later than 65 days after the formal receipt. That public hearing has to be closed 35 days after it opens. And then following the close of the public hearing, the decision must be rendered within 65 days of that closing. Or again, within 35 days after inland wetlands has decided. If no public hearing is held, so for instance, if it's a site plan, or if it's a subdivision, not a re-subdivision, the decision has to take place within 65 days of receipt, again, or 35 days after wetlands. However, applicants are granted within that statutory time clock at any point along the process, receipt, open a public hearing, close a public hearing, decision. At any phase there is a free-floating 65 days in which public hearings can be extended, deliberations can be extended, again, at the consent of the applicant. There are a couple of types of decisions, and again, these are primarily planning and zoning. Zoning Board of Appeals tends to be just an up or down, yes or no. Appeals and denials, but then there are also modified approvals, particularly in the case of a special permit, a conditional approval. You can have conditional subdivision approvals or conditional special permit approvals, or denials without prejudice, which essentially is some sort of procedural defect or some sort of minor issue that would allow the applicant to come back and fix what was wrong or incomplete or incorrect about it and resubmit. Each commission should state on the record reasons for denial, and are allowed to reconsider their own decisions. There are a couple of circumstances where approvals are automatic, and this is usually what we call a problem with the statutory time clock. This is generally for either site plans or subdivisions. If you blow your timeframes, if you don't close your public hearing, or you don't open the public hearing within 65 days of receipt, you blow through one of those statutory time clocks that we talked about, it is deemed approved, a site plan or a subdivision. This is not take the case in zoning board of appeals or special permits, but generally speaking, it is a really, really, really good idea to know what your time clock is and to not mess that up, because that creates all kinds of legal problems. A couple of internal procedural things in terms of commissioner participation in meetings. There are cases where a commissioner should not participate in discussions and should not participate in decisions. If there's a conflict of interest, either personal or financial, between the applicant and or the property and a commissioner, that commissioner should probably recuse. If there has been evidence of prejudgment or ex parte communication that the commissioner has shown to have bias or has been involved with sort of a pre-vetting of this, doing independent research without putting it on the record. or a disclosure of specialized knowledge with ex parte evidence, um, or a commissioner who shows up at the second part of the hearing, didn't listen to the tape, didn't familiarize themselves with the record, and makes an act to decide the matter. Those are problematic, and those commissioners should not be involved in the decision making. In terms of conflict of interest, again, I'm not your attorney, and you should always seek attorney's advice on this. But financial interests include the interest of the commissioners or members of the immediate family. It also includes anything that might financially benefit the commissioner, which may be greater than the benefit overall to the community. Personal interest would include close friendships or other associations. And it doesn't need to be an actual conflict. If there is reason to perceive a conflict, even if there is no obvious financial gain, perception of a conflict can also be a significant problem, and that's a matter of public trust. In terms of holding a meeting itself, any hearing or any scheduled meeting constitutes a meeting. It is a legal and open proceeding. Anytime you have a quorum of a multi-member public agency like planning, zoning board of appeals, any communication. So many times, the staff will send out an email asking a question to commissioners or making a statement to commissioners as a piece of information, and commissioners might reply all to that email, which would include all of the members of the Planning and Zoning Commission, all the members of the Zoning Board of Appeals. That constitutes a meeting because it is communication amongst all members or most members of the commission. And a meeting can be something that takes place in person, as we discovered during COVID, and even now via phone, via Zoom, hybrid. These are all meetings. Things that are not deemed public meetings is a caucus of members of a single political party, even if it is a larger number of them. A staff meeting between staff and a single member of a public agency. Communication regarding the notice of meetings, or again, if it's just publication of the agenda, who's available, that sort of thing. If it's just about the scheduling or noticing of a meeting, that does not constitute a meeting. And a quorum, let's say, a majority of your selectmen show up at a planning and zoning meeting because they're interested in something. Just because they happen to all be there doesn't mean there's also a meeting of the Board of Selectmen happening. In terms of excluding the public from meetings, there are very, very specific and very limited times where the public can be excluded. If it's talking about, and this is not generally planning or zoning or ZBA, but regarding issues regarding site selection or lease or purchase or sale of real estate, that could create a problem with the pricing. Public is allowed to be excluded for that. Discussion of matters that would result in disclosure of public documents that are protected from disclosure, the public can be excluded from that. Executive sessions are allowed to be exclusive of the public. And the commission can invite members of other agencies, they can invite staff and other people to an executive session, but it does not have to be open to the public. The minutes did not have to reflect what happened in that executive session, but it does have to reflect who attended, other than job applicants. A couple of the reasons for an executive session would be personnel issues, which are allowed to be private, litigation, pending claims, lawsuits, purchase and sale of lands that we discussed, and also public security issues. All of those things are exemptions to the sort of the open meeting rules. In terms of fact-finding, all your commissions, when you are asked to make a judgment call, you are charged with evaluating evidence, credibility of witnesses, and as well as experts that testify, say, environmental experts, traffic experts, civil engineers. Commissions must defer to expert testimony on technical issues beyond the expertise of lay commissions. For instance, if there are environmental impacts and you have a recognized expert saying that the environment will be irreparably harmed, the commission cannot substitute their own lay judgment for the testimony of that expert unless there is also an expert who testifies in the opposite direction. In that case, the commission is charged with weighing the evidence and the credibility of the witnesses. But in a highly technical circumstance, the commission is not allowed to substitute their expertise for that of established expert witnesses. So we buzzed through. It's almost exactly 7 o'clock. I'm happy to stick around for specific questions, but that concludes the bulk of my presentation.
Hi, I had a question. I'm Barbara
Go ahead.
Sequenzia. I'm just wondering who the zoning enforcement officer is in Portland.
I am authorized to be a zoning enforcement officer, as is Dan.
Oh, okay.
So it's
Very
sort
good.
of like you know, it's more like police officers than it is like a Highlander. You know, there can be more than one.
I see. Okay. Thanks.
Typically, John is doing the enforcement, the actual action. I'm doing a lot of some of the FaceTime. I won't say a lot because John has done quite a bit himself. But yeah, we've been working together. But I would say he carries the heaviest burden on the enforcement action, for sure. And I thank him for that every day.
But yeah, but in a pinch, Dan's able to crack some skulls too.
Okay, great. Thanks.
Victoria,
Bob Ellsworth, I have a couple questions.
go ahead, Bob.
Okay. First of all, thank you for doing this. I learned a lot, especially about grandfathered properties and subdivision regulations. That was very helpful. My first question is, as I'm sure you know, Portland High has a town engineer which reviews applications, produces a document for the commission, highlighting any concerns, issues that he sees. And I rely primarily on that document as far as my evaluation of the application. Is that fulfilling my duties, or should I be doing more than that?
No, I think that's I think a very appropriate thing that, you know, the commission has identified and basically hired this person as an expert, you know, as your technical expert. You know, there may be circumstances, and you know, it depends. I mean, I think you shouldn't necessarily treat their word as absolute gospel. You're not allowed to disagree, particularly if there are sort of areas of judgment where there could, you know, so for instance, in the case of stormwater management, you know, there's more than one way to manage stormwater in a lot of circumstances. You know, you could pipe it into a town system, you could create a swale, you could create a rain garden, you could create galleries. There's not a single answer to that. I think it's certainly okay to either push back about alternatives, but generally speaking, you know, if you do not have a civil engineering degree,
Right.
you probably shouldn't say, Jeff, your calcs are wrong here. You know, the stormwater is you know, at 6 cubic feet per second, not 8 cubic feet per second. That's probably not something that you would want to do. But yeah, I mean, generally speaking, the town has vetted this person as an expert in these particular technical areas, and giving them authority to provide those opinions that you then make binding upon the applicant. That's certainly appropriate.
Okay, good. That helps. Second question is, and it really has to do with zoning board of appeals. Now, I understand an application ends up in front of the board of appeals if the zoning enforcement officer denies the application. My question is, suppose the Planning and Zoning Commission rejects an application for a subjective reason, such as it doesn't meet the POCD or so, you know, our interpretation of the POCD. Is that an application that might end up in front of the zoning board of appeals?
Generally, no. That would usually be if it's something where the Planning and Zoning Commission is invoking the Plan of Conservation and Development as a reason for denial. That would generally be a special permit or a special exception, in which case the appeal path would go to Superior Court. and not the ZBA.
Okay. Okay,
And it's awfully to further opine on that. I mean, that part is a fact. It's awfully difficult unless there's something in black and white in the plan of conservation and development that says we will extend the sewer in this area or we will allow gas stations on this corner. Unless it's that blatant, overturning an application on the grounds of not conforming with the plan of conservation and development is an awfully high bar for the applicant to overturn.
gotcha. Okay, thanks. Thanks again.
Yeah. I'm sorry, Victoria, do you have a question?
I guess a process question or observation, just confirming that when an issue gets to the zoning board of appeals, that a decision has already been made at a lower level, and that is the topic of the discussion at the ZBA. And that the applicant doesn't have the flexibility to come up with a different argument that wasn't presented to the original decision maker.
Yeah, I think that's correct. However, I mean, it actually is sort of a question that I would have. In the case of a variance, it's not necessarily a denial that triggers it, because there wouldn't necessarily be that paper trail wouldn't necessarily have been created. I'm guessing in most parts, and Dan, you can correct me if I'm wrong. Someone doesn't apply for something with, a barn in the rear yard setback and wait for your denial and my denial to then seek a variance. If someone wants to do something that requires a variance, they'll generally go right past the zoning permit question and jump right to the ZBA, because we know that, that structure isn't allowed in that setback.
So it's not really an appeal.
I don't think, I mean, I suppose a variance could be structured as no, it's not really. A variance is a variance. Although, really the question is, do you have to wait for the zoning officer to say nope before you go and get your variance? You really don't. It's reading the regulations, producing a site plan. That this isn't allowed in that spot, or that structure isn't allowed to be this high. So it's not really a denial that creates it. It's just the regulations.
Appeals tend to be rare for me because I usually go through the regulations with the individual if they're not meeting them, and I kind of explain the situation to them. And ideally, and most of the times, I can literally point to the text in the regs. So unless they vehemently disagree with how I'm reading the regulations or interpreting them, that's usually when an appeal occurs. So it's pretty rare that we will get an appeal, because I'm not trying to enforce or make up any regs other than what we have. But what we have is enough. Is fine unless we change them. So yeah, it's pretty rare that I think I've only had one or two appeals in my entire career. So it's I try to work with people, explain the regulations, and then help them through the variance process.
I had one in Portland. Had to do with chicken.
Yeah, that's true. That's true. He did, yes. That may come. Well, that's another day.
Other questions?
Yeah. Anybody else? Anything? Well, I certainly appreciate all of your time. Oh, did you have one, Cynthia? Oh, yeah, I think you're muted.
Okay, question is, if we have questions about understanding any of these regulations, do we go to you, Dan, first, or do we go to John?
Not it.
I would say me right now. I will admit John certainly has more knowledge than I do.
I'm a lot
and
older.
I certainly seek guidance from John from time to time. It's certainly a source that I trust. I would say I rely on him in a little bit. So yeah, I would direct your questions to me. I will try to field them. If I need any advice or an input, I will reach out to either John, which I've certainly done in the past, or to our attorney, Carrie Olson. As you know, even I don't think it happens as much in ZBA, but certainly our town engineer Jeff Jacobson is great at what he does, just like John. And so we're very fortunate to have you know the input from experts like these to give you the proper information so you can make the best decision possible.
Thank you. And thank you to both of you for doing this program.
Yes, thank you.
You,
John did all of the heavy lifting. I was listening, and this was a good refresher for me as well, to be honest.
I will, for the record, because this is recording, I will thank Casio and as well as the law firm Heller and Sage, who has, you know, made a lot of this material available as well.
Can we get printouts of that, of your presentation?
Yep.
Great.
I'll give it to Dan tomorrow.
I'm sorry for being late.
And I believe the meeting was recorded, so that can be available. People can go back and watch it.
Right.
I'll be once I work with IT to get this posted on the internet. I'll send out the link, and it'll be. I'm gonna try to, especially this one, provide this to new members, so they're a little more comfortable going into meetings. I know, like Barbara got a little bit almost, you know, she had her first meeting and she was already getting seated. So this I think will help a little bit, and I certainly appreciate Barbara rolling with the punches on that one,
Thank you.
because that was not controversial meeting, just like Joan, you know, taking the reins of chair. So yeah, this will certainly be something will be available to you whenever you'd like to watch it if you need a refresher. But certainly we'll be providing it to new members.
Thank you.
Well, thank you all for your time and participation and for your service to the town of Portland.
Thank you so much, everybody. We'll probably do another one of these September, October, early November, just to wrap all this up for your required OPM training, and then everyone will be good for 2 years, and then we'll do it again.
Did you say 4 hours?
Yes, yep. So we did the first one, which was an hour required for affordable housing. Attorney Olson did that. If you need the link again, let me know. I'm keeping a spreadsheet of who's participated and who's let me know they've watched the videos. And then we'll be doing two more sessions. So yeah, it's a total of 4 hours that's required.
Okay.
Have a good evening, folks.
Thank
All right,
you.
well, thank you very much. Have a wonderful night.
Thanks.